Hey everybody, welcome back to Counsel, a Hirschler video series focused on legal and business trends keeping employers up at night in these uncertain times. My name is Andy Sherrod and I'm joined virtually today by my colleague Jaime Wisegarver. Both of us are members of Hirschler's employment law team. We've been engaging in a series of discussions about some new Virginia employment laws that will take effect this summer. Today's installment is going to focus on a new non-compete statute. Jaime, tell us about it.
Sure. Under the new non-compete law, employers cannot enforce or threaten to enforce a non-compete against a low-wage worker. A low-wage employee is someone who makes less than the average weekly wage in Virginia, which earlier this year, that number was around $1,000. But again, that average weekly wage can fluctuate. Employees can bring a lawsuit to void a non-compete. They can seek an injunction against their employer. They can seek fees, liquidated damages. There are civil penalties that can be imposed by the Commissioner of the Department of Labor against employers that violate this law. So it's a pretty significant change, Andy, which I know you've given some thought to the practical impact. Can you tell our listeners a little bit about that?
Yeah, thanks, Jaime. I think this could have a big impact. Historically, in Virginia, the enforceability of a non-compete was really controlled by what the court would consider reasonable and narrow enough to just protect the company's legitimate business interests without hindering the employee's ability to, earn a living. But now this statute has, basically eliminated an entire class of employees from being subject to traditional non-competes. So I think first and foremost, given that the effective date of this new law is July 1, if companies had plans to implement some non-competes, they better do it soon. Regardless of the deadline under the statute, though, I think that employers really need to take a hard look at the types of employees that they would seek to put under traditional non-competes. They may want to really think hard about, are these employees highly compensated? Are these employees folks that have sensitive business information, key customer relationships? Those are the types of employees that you can still put under a traditional non-compete if they earn more than the statutory threshold. But I think you want to make those decisions so that you're not having to worry about whether or not your employees are above or below this weekly wage, because I think the low wage label here is a little bit of a misnomer, and you really need to keep track of that. For the lower compensated employees, remember, you can still keep those folks under traditional confidentiality agreements, and those do have a lot of impact and a positive impact on your business. Lastly, I think, at times in the past, some businesses would, have folks enter into non-competes and try to, send cease and desist letters to employees sort of as a chilling effect to try to thwart competition. And obviously under this statute, that's a huge no-no because, it can actually come back at your business because the employee would then have the ability to sue you and get attorney's fees and damages if you take that path.
It sounds to me that the takeaway is that this is a very employee-friendly law, Andy, which is new for Virginia. We are moving in the direction of California and Massachusetts, it seems. To our listeners, thank you for listening. If you have any questions or if you have some suggestions for a topic that you'd like for us to cover on Couch Counsel, please feel free to contact us. Thank you and stay well.